let's call the meeting to order, please. Good evening, all. It is Wednesday, June 12th, 2024, time now 7:32 p.m. This is the meeting of the Municipal Land Use Board of the Borough of River Edge. This meeting of the Municipal Land Use Board is being held remotely and recorded via Zoom due to Borough Council chambers unavailability and is in compliance with the provisions of the Open Public Meetings Act and associated regulations. Notice of this remote meeting, was published in the Bergen Record, posted on the front doors of Borough Hall, and posted on the borough's website. The notice included the dial-in and login information necessary for public participation and access to this meeting remotely. A copy of the agenda for this meeting was made available on the borough's website near the posting of the meeting notice and included the dial-in and login information. During the public comment period of this meeting, if you would like to make a public comment, please press the raise hand button on Zoom or dial *9 on your telephone keypad to raise your hand. The board will address you by name or by the last 4 digits of your telephone number. You may mute and unmute yourself by pressing the microphone icon on Zoom or dialing *6 on your telephone keypad. You must state your name and address prior to making a public comment. With that, I will also, for the record, we're going to have a curfew this evening of 9:30 p.m. And with that, I will ask Ms. Steinle to call the roll, please.
Thank you. Mr. Mayor is excused tonight. Mr. Caslen?
Here.
Ms. Boland?
Here.
Mr. Merman?
Here.
Mr. Pfeffer?
Here.
Mr. Cray?
Here.
Mr. Kinigo?
Here.
Councilman Glass?
Here.
Mr. Gibbons?
Here.
And Mr. Bastide is absent tonight. Also present, Mr. Behrens, our board planner, and Mr. Depkin, our zoning official.
Okay. Thank you very much. First item on the agenda this evening, under the approval of minutes, we have a draft set of minutes from our May 22nd, 2024 meeting. Draft was circulated to the board for review prior to this evening's meeting, and I open it to the board for comments and or questions on the draft minutes.
Mr. Chairman,
Mr. Merman.
I have reviewed the minutes and I find them correct and recommend them for recommendation to the board if no other member has a comment.
Okay, thank you, sir. Any other comments, questions from the board?
I had one, just spelling change. Mr. Zabo's name is Szabo, so just throughout the minutes.
Okay. And with that one correction noted, I will look for a motion on the minutes, please.
I'm sorry, Mr. Chairman. I'm gonna abstain from voting. I apologize. I didn't have time to review the minutes.
Okay, noted, Mr. Councilman. So I'll still look for a motion on the minutes, please.
So moved.
Thank you, Mr. Kinigo. Thank you, Mr. Cray. All in favor?
Aye.
Other than Councilman Glass, any abstained or any opposed? Okay, thank you very much. Next item on our agenda this evening under memorializations, we have Hang Zhang Inc. Properties 900 Kindermack Road, Block 209, Lot 21. Draft resolution granting site plan approval on the application for a food handler's license. Draft was circulated to the board prior to this evening's meeting for review and open to the board for comments or questions.
Mr. Chairman, likewise, I reviewed this memorialization and found it acceptable and recommended for acceptance by the board if another member does not have any comments.
Okay, thank you, Mr. Murray. Any other comments or questions from the board?
There was just one typo. In the fourth whereas clause, it said previously operated a restaurant, but it should be as a restaurant. So I made that change.
Okay. Okay, noted. All right, with that one change, I will look for a motion on this resolution.
So moved.
Thank you, Mr. Gibbons. Is there a second?
Second.
Thank you, Ms. Boland. Ms. Steinle, when you're ready.
Mr. Caslin,
Yes.
Ms. Boland,
yes,
Mr. Merman,
yes,
Mr. Pfeffer,
Yes.
Mr. Cray,
Yes.
Mr. Kanigo,
Yes.
Councilman Glass,
Yes.
Mr. Gibbons.
Yes.
The motion passes.
Okay, thank you, everyone. We're going to adjust our agenda slightly this evening, with the councilman being present. We're going to move old business up at this time to cover discussion regarding ordinance number 24-14, amending the Borough Land Use Code. The discussion will center around consistency of the amended code with the master plan. Draft of the ordinance was circulated for the review prior to this evening's meeting, and I open it to the board for discussion at this time.
Well, and I'll just give a little direction in that regard. So this is the ordinance, obviously, that the board recommended to the mayor and council. And as far as I'm aware, the mayor and council introduced the ordinance as recommended by this board on May 30th. And in accordance with the municipal land use law, once the development ordinance is introduced by the governing body, that ordinance has to get forwarded to the land use board in this case to conduct what's called a master plan consistency review. So the task before the board is to identify if there are any inconsistencies with the proposed ordinance amendments as compared to the borough's existing master plan documents. And the board can also offer any recommendations for the mayor and council to consider. So to aid the board in its review, I did take a look at the borough's adopted master plan documents, which include the 1984 master plan, as well as the more recent 2022 re-examination report amendment, which this board adopted. And starting with the 1984 master plan, I just thought it was interesting to note that at that time, the master plan identified that or noted that 90% of the housing stock at that time was developed before 1959. And I don't think a lot of that has changed since then. Obviously, there have been some knockdowns and additions and alterations, but I think in general, it's recognized that we have an older housing stock and that people will seek to continue to modernize their housing. And I think this is, what this ordinance seems to address in part. The master plan also recognizes that the town at that point in time is fully developed. So that, there's nowhere else to build. We have what we have. And again, people will continue to seek to modernize and, improve their properties. With respect to specific provisions in the master plan, there's one that pertains to residential development in particular. And that goal is, it states to maintain the character and viability of all established residential neighborhoods. And, obviously this is aligned with certainly the board's intent when we prepared this ordinance amendment, which, just to summarize, what a few of those amendments entail. One was the required set aside for rear yard amenities. One was creating discounts for certain types of permeable coverages. One was updating terminology for sake of clarity. And then finally to identify accessory structures that had not been previously captured in the ordinance. So and then finally, I'll close with a review of the 2022 reexamination report, which was created and adopted by this board essentially to facilitate these ordinance improvements. So the board had considered those at that time. That was the first step in the process. The second part was this ordinance. And certainly these ordinance amendments are very much consistent with that reexamination report amendment. So with respect to the board's task of finding any inconsistencies, having poured through, every page of those documents, I couldn't find any inconsistencies. Certainly up to the board if they have. But again, the task is whether or not the ordinance is inconsistent with the master plan, and again, to offer recommendations. So I will then turn it over to the board. Thank you.
Okay, thank you, Mr. Behrens. Comments from the board?
I have a couple of, hey, Mr. Behrens, it's been a while since I looked at it, honestly, but I did review it again.
Okay.
One minor thing, correct me if I'm wrong. A part of the new language has to do with, and I'm not sure what we're calling it, like the overhang above a front door, there's a height limitation that it can't exceed the height of the first story of the structure. Is
So-
that correct?
I think you're referring to porticos and the new
Yes.
porch provision, right? So
Thank you.
in the existing ordinance, there was an encroachment that was permitted, subject to certain dimensional requirements, and that it couldn't exceed the first floor, essentially, of the house in this case. So,
Thank you, thank you. So, yeah, I just want to make the board aware. I think I'll share with you guys. There's several things in this in the new language that I consider, meaningfully restrictive. I'm not providing an opinion on that. I just want to make you aware of my thoughts around it. But also, Mr. Behrens, if I understand correctly, there's all kinds of residential single family dwellings in this borough that have porticos that greatly exceed 1 story. So I just want to make the board aware of that and the restrictive nature of that. If you think about it, I don't know if that means the peak, the ridge line of the portico can't exceed the first story. Think about, go ahead.
The restriction on the first story portico is only with respect to that bonus encroachment. So if it's a 1-story portico, you can encroach a little bit, and it's only a certain amount of square footage. You can encroach a certain amount into the front yard setback. But if they want to go above, it's not a ban on 2nd-story porticos. They would just have to come to the board if they if they encroach into the front yard setback. For that 2nd-story portico.
Thank you for clarifying that. I'm trying to envision a scenario where you would have that encroachment and not exceed 1 story.
well, I think this is a case where, and I'm thinking about how this ordinance would allow for a front porch, let's say. So you would have this, encroachment beyond the 30-foot setback line, 6 feet into the front yard. And when it says 1 story, I think it means, the peak of that, whether it's a shed roof or a gable roof, not exceeding, I guess the first floor of the second, the floor of the 2nd story, essentially. Certainly
Yeah.
open to interpretation.
I know, is it like, it doesn't say kind of like the ceiling
Well,
of
I
think that's what your interpretation is. I don't know if Mr. Depkin
I
has
think the
experience with
intent is that it can't be a multi-level structure, meaning, I'll use the example of a porch. You can't have, in some cases they're nice, but, sort of these porches with the columns that extend to the
Right.
main roof, like that wouldn't be permitted under this ordinance if it extends into the required front yard. If it's within the setback, to Marina's point, you can build as tall as you want. And, there may be a few of those houses, older houses throughout town, but most of the newer porches, I would say, are limited to that 1 story. And I think that's the intent here. So
Okay, that's good. I mean, I guess there's some flexibility in how it's interpreted. But again, I'm struggling to envision a scenario where you apply, you're complying with that additional encroachment and the peak of the structure doesn't exceed the first story of the home.
So your
know what I
point
mean?
is, and well taken, that technically we'll say in the case of a gable roof portico, that peak may in fact extend
Yeah,
above
okay.
the 2nd floor between the windows, let's say, which is a common.
Right. Right.
I see what you're saying from a technical standpoint. I think the way it's been interpreted, as far as I know, is that there's some flexibility there. Again, meaning that the space can't extend, or maybe one way to look at it is that the bottom of the portico roof can't extend above the floor.
That I think would be more practical.
So it doesn't become a multi-level structure.
Right.
That's really the
But
goal.
that's not how it reads now.
Okay.
Again, I'm not suggesting any action or change. I find that to be a little bit difficult. And the language maybe could be improved, but as long as we all have a clear understanding and it's interpreted properly moving forward. And then just for the benefit of the board, I do find that the key new provisions in this, that we're making to this ordinance are restrictive on people looking to build in our borough, build in the borough, build new homes or expand their homes in the borough. I think everyone's aware of that. I'm just stating the obvious. Thank you. That's it.
I would just add to the first point, if some clarity is warranted and we don't change the intent or the substance of we're talking about the one-story provision, that a change like that can be made as long as it's not deemed to be substantial, as long as it doesn't modify the intent. So maybe that's something, Maria.
All right, that might be a good thing to do. Thank you.
Yeah.
Further comments, questions?
I have a question for Tom.
Okay.
So as written, do we have to modify this proposed ordinance, or can we just go ahead and deem it in accordance with the master plan?
Yeah, well, the ordinance has been introduced, so if there's any major modifications, the mayor and council would have to reintroduce it. And the only thing the board can do is offer recommendations at this point with respect to modifications. So, Councilman Glass just gave some comments. So, the board again can offer recommendations, but any major, substantial modifications would require reintroduction of the ordinance and would be subject to the council, wanting to make those changes.
And I might add, if the board wants to add some additional clarifying language regarding the front porch encroachment, we could add that into our resolution, and it's up to the council whether they want to incorporate that language or not.
Can we hear the actual language that we're talking about as being confusing or
So
just unclear?
I'll read what the new language will say. It's on page 5 of the ordinance under section 416-13, well, section 7 of the ordinance. Of the code, it will be 416-13, subsection C4. And it'll state covered front porches and awnings may project no more than 6 feet into a required front yard setback, provided same complies with all other setback and coverage requirements and do not exceed the first story of the building in height.
I don't see it as confusing. I think it's straightforward, but I also have no objection if you guys want to change it. It seems based on our history and what we've always done here and what we discussed here, it seems fairly clear to me.
And that first story reference was actually in the existing ordinance. That's not been changed.
Yeah, that was already in there.
So,
Yeah, I'm just thinking if something doesn't work well, we should fix it. Again, think about the first story. It can't exceed the
Yep.
first story. So think about a portico, right? The height of the portico cannot exceed the first story. That's what the language says.
no, point taken. So as Ms. Steinle suggested, we can suggest in our resolution to the board, resolution as to consistency this evening, we can make that suggestion that be clarified. So.
Okay, one other thing, Mr. Chairman, if we do that, that's fine. Tonight, it's my understanding, we need a motion that the proposed ordinance is in conformity with the master plan. Is that correct?
Consistent with the master plan. That's correct.
Okay. So if there's no further discussion, we can go on to a motion.
Ken, anything further from the board? Okay, that sounds, I
Okay.
will take that as being no further comment, and I'll look for a motion.
And I'll make a motion that the regarding proposed ordinance 2414, that the board finds that it is in conformity with the master plan as described by the planner, and that the minor revisions that we just discussed regarding the porticos be noted for the mayor and council to consider.
There's second to that motion?
Second.
Thank you, Mr. Pfeffer. Ms. Steinle, you're ready.
All right, thank you. Mr. Caslin,
Yes.
Ms. Boland,
yes,
Mr. Merman,
Yes,
Mr. Pfeffer,
Yes.
Mr. Cray,
Yes.
Mr. Kanigo,
Yes.
Councilman Glass,
Yes.
Mr. Gibbons.
yes,
Okay, the motion passes.
Okay, thank you, everyone. At this time, I will bid goodnight to the councilman as we move on to our next agenda item.
Thank you, everyone, for entertaining my comments tonight. Have a good night.
Thank you, Councilman. You
Bye.
too.
good night.
Okay, at this time, we are going to move on in our agenda under completeness review. Applicant is Happy Doggy LLC. Property is 47 River Edge Road, Block 409, Lot 3. Have proposed addition of overnight boarding, training and maintenance of dogs, and outdoor operation of a retail business. Ms. Steinle, I will turn to you.
Hello, so we did receive application documents regarding this matter, including an application form, site plan checklist, requesting waivers for every checklist item, a signed survey prepared by Stephen L. Kestner, dated April 13th, 2022, signed site plan document, the signature and name, I couldn't read, but it was dated June 6th, 2024. And then unsigned, undated draft site plans with a floor plan imposed, unsigned and undated floor plans, and unsigned and undated photo renderings. The signed and dated site plan did not provide the correct scale, didn't include a zoning table, didn't indicate dimensions of setbacks, parking stalls, fencing, or other proposed improvements, if any, and did not include the location of property boundary lines. Although the applicant did provide notice, as is the board's typical procedure where we review completeness on the same day as the public hearing, and the proofs submitted were sufficient, I do not think that the application documents are sufficient, and I'll let Mr. Behrens explain as well.
Barnes?
Thank you, Marina. So I'm going to give my overview, at least of the understanding of the application. So, yeah, it's a D1 use variance application is my understanding, because the proposed overnight keeping of dogs, boarding of dogs, the outdoor training or outdoor aspect of this use, as well as the proposed hours of operation, would trigger the need for a D1 use variance. And it appears that if you look at the 2022 survey as compared to the document labeled site plan, there's obviously changes that are being made. And it looks like there's, I guess, it's hard to read the label, but some type of grass area in the rear yard that, would seem to be intended for dogs for some type of use. And, maybe there would be operational testimony at some point about that. And there do seem to be some dimensional accuracies, and the site plan document itself seems to lack what we would, typically require on a site plan. Some of those Marina mentioned. So from a dimensional aspect, some of the parking spaces are 6 feet wide, zoning information, et cetera. So I know initially there was a site plan submitted that, wasn't signed and sealed. The applicant had done that, I think attempted to put on property lines, which again, there seemed to be some inaccuracies, excuse me. So the plan itself seems to be more conceptual in nature than qualifying as an actual site plan, meeting all the checklist requirements. So I'm going to ask the applicant, they're the applicant's representative, what relief they're seeking, because there may be an opportunity to review the use aspect or not. And I say or not because it seems like the outdoor space and the site plan improvements are related to the use, and sort of bifurcate the review. Or, they might have to come back with a more developed site plan. And so, again, I'll turn it over to the applicant's attorney to help us understand what relief exactly the applicant is requesting this evening.
Right, my name is Jay Atkins. I happen to have my law office in River Edge at 887 Kindercamack Road. It's been here for, 26 years. I'm a little staggered by the professional's response here. A continued certificate of occupancy was granted to this applicant in April. She's operating her business. Our proposal proposes no changes to the site. It's an existing multi-use building that's been in existence in this borough for over 50 years. I actually have a letter from Mr. Behrens that he wrote to another lawyer last year saying that this mixed use has existed since at least 1984, and that some borough documents are lost, but there's no question that there's a studio residence and a business part to this. My client applied for certificate of occupancy and was granted. What she didn't get granted and what she indicated to when she applied for it is that her dog grooming business, she wanted to have an overnight with some dogs staying over and be able to walk them after 11 o'clock. I might add, there's been nothing added to the property. She took over the property as exists as it does. The only thing that was added was a fence for which she obtained a permit from the town zoning official and paid the fee. So she occupies a building that has existed in the same form, in the same dimension, in the same location, I guess from time immemorial. She operates her business and she wants to board some dogs overnight and at night walk them occasionally. By the way, in her residence, she could have a dog or two or three or four. There's no limit, and she could walk those dogs. What I don't fathom is how technical the look at this application has become. This is not a major zoning application. This is an application by an existing user, an existing business in this town who has a CO to expand to allow her to board dogs from 11 p.m. to 5 a.m. It's interesting. I presume Dunkin' Donuts, which can open from 5 to 11, there's probably somebody in there baking donuts and bagels at 3:30 or 4 in the morning so the public can buy them at 5. I go by Ace Hardware all the time, and I see all those garbage cans and stuff on the outside. All my client wants to do is have the dogs that she grooms stay overnight occasionally. And if they have to go to the bathroom, walk them in her fenced-in backyard. That's it. She's not changing anything other than that. And she's asking this board for that approval. Quite frankly, I've advised her I don't think she needs it because I think she could do it without your approval. But she's unwilling to risk a summons and a trial in municipal court. But I think since she lives there, she could have dogs sleep there anyway. But at the end of the day, we want to do what's right and transparent in this town. And I don't see, and I would ask this board to grant waivers, there's no reason for all that technical detail. The house exists. She's not doing anything. She's renting it from the owner. She lives there and has her business there. And I don't know what else you would need to see, because if you denied it, she'd still have the same business. And if you granted it, she'd still have the same business at the same site. Now,
All right,
that's
so-
basically what I have to say.
So I hear you. I'm going to clarify a few points. So beginning with my letter from last April, that had to do with the property owner trying to sell the property. And at that time, they wanted a zoning certificate for the non-conforming residential apartment on the second floor. That means that the site is in the C1 zone where residential uses are not permitted. There's been an apartment there, which we acknowledge since at least the 80s. There's some record of that. The problem is you can't issue a zoning certificate as requested. The municipal land use law gives 3 ways that you can grant
Mr.
relief
Barron,
in that
she
way.
has a CO for
Just,
it.
sir, just
Mr. Atkins, why don't you let
you had
our
your minute.
professional finish?
You had
okay?
your minute. So
Thank you.
point being, it's clear that the property never got a use variance or any other valid prior approval for the residential use, but the borough has allowed it to continue. That doesn't mean it doesn't need use variance relief. It doesn't mean it was ever permitted in any formal way. So I'm glad you brought up that letter because I didn't even mention that in the required D1 use variance relief. Second, with respect to site plan changes, anyone that's put the 2 pieces of paper together, meaning the 2022 property survey and what we're calling a site plan, there are visible differences. One is the lack of macadam and a patio that's been reshaped, and what is an illegible label, but appears to be some sort of grass area, which again, presumably is intended to be used by dogs, either for going to the bathroom, for training, etc. I'm not suggesting these are big deals, but I'm suggesting that you're the one complicating the application. If we just called it what it is, the board could move on with its business.
You
Can I
have
make a
my
comment?
position.
Can I
There's
make a
been no
comment,
change
please?
to property. There's no area prepared for dogs in the backyard. The only thing done was a fence with a permit. My client occupied an existing building.
The board
As
requests.
a CO.
The board, when reviewing applications, requires an existing site survey. The existing site survey that you provided dated 2022 shows different improvements than your site plan. It's that simple.
And I'm asking for a waiver. And I think that's up to the board.
Well, Mr. Atkins, you've been doing this a long time, clearly.
I have been.
Okay, so you can appreciate the fact that we as a board expect certain requirements for submissions, which, as you can tell from our professionals' review, doesn't quite hit the mark. Okay, now typically, we appreciate you're trying to substantiate your client has not changed anything, but we have no way of seeing that in a documentary fashion. That's what the submissions are for. Now, with that, we do have, Ms. Steinle, let me ask you this. From a legal requirement standpoint, the notice has been presented or has been properly made of the application. Is that correct?
There was notice provided for the use change only, yes.
For use change only. Okay.
Mhm.
Let me turn to the
I
board.
don't understand what that means.
For the, you provided the notice for the change use.
As opposed to,
We don't know if there's any other variances that could be required based on the lack of information provided in the survey compared to the site plan.
Well, I'll jump in here. And again, this does not need to get overly complicated, and it's become overly complicated. There are a few dimensional issues. Again, based on the site, what we're calling a site plan submitted by your architect or whoever, you have 6-foot wide parking spaces, for instance. The borough doesn't allow 6-foot wide parking spaces. You have the overnight parking of at least 2 commercial vehicles. The borough doesn't allow overnight parking of commercial vehicles. So again, if we just address these things head on, they're not complicated, but it's helpful to identify them. So, I think we have 2 approaches that the board can consider. One is that they can consider this plan as conceptual and maybe hear testimony about the use. But again, I think the outdoor component of that warrants, it's integral to the use, so we need some level of accuracy, but I think it more or less, indicates what they're trying to do. Or, they'd have to come back with a more complete site plan.
All right. Let me open it to comments from the board at this time. If you've heard from the professionals, comments from the board as far as completeness at this time. Mr. Kinigo.
I'll break the ice, Mr. Chairman.
Okay, Mr. Merman.
I have visited the site personally. on, Sunday, June 2nd. Had a discussion, on site with the applicant. Reviewed with the applicant what was submitted at the time. And I personally showed her and informed her what was incomplete with their site plan. And, for one, I think that they had sufficient time to make the corrections. And I personally do not want to review a haphazard set of documents in order to base my decision making on. I will also note that the real question here besides that is the 24-hour use of the property, which I consider a conditional use. And that's what we're really shooting for, besides what the planner mentioned with overnight parking and commercial vehicles. And there are some other issues, but from the standpoint of being a board member and a professional myself, I want a complete package before I start to review any item, and the complete package will assist in basing my decisions. And I don't know how the other members feel, but that's the way I look at it.
Mr. Kanigo.
Mr. Merman said it better than I could have, and I'm with the professionals whom I will read between the lines, and I think that they want the further documentation. And I'd like to see it as well. So I'm with Mr. Merman and the professionals.
Mr. Gibbons?
I same, I think we need to see the whole picture before we can make any real determination on this. So I'd like to see all the documentation as well.
Thank you, sir. Further comments? Okay. I will look for a motion on the completeness of this application at this time.
I'll attempt a motion, Mr. Chairman,
Mr. Merman?
for the reasons just stated. I find that and the board seems to agree that what we have in hand is incomplete to arrive upon a rational decision.
Okay, is there a second?
Second.
Thank you, Mr. Kanigo. Ms. Tyler?
All right, so a vote yes means you're agreeing that it's not complete. Mr. Caslin,
Yes.
Ms. Boland,
Yes.
Mr. Merman,
Yes,
Mr. Pfeffer,
Yes.
Mr. Cray,
Yes.
Mr. Kanigo,
Yes.
Mr. Gibbons.
Yes,
Okay, the motion passes. The application is been deemed incomplete.
So, Mr. Atkins, I strongly recommend that you have your client's professionals work with our professionals to achieve a satisfactory site plan that can be reviewed by this board. I think that that would be in your client's best interest to move this forward.
That may be, but one of the things I want to alert the board to is if Mr. Perrins is suggesting that we apply for a use variance for the residents, that's off the table here. That CO has been issued. And in his letter, he says that the borough has lost the records in its history of its zoning. So, we can't address that.
Well, if you're familiar with the municipal land use law, I think you know the answer to that. We can deal with that later. So the last thing we want to do is create additional hurdles for your client. That is the last.
Because we're
thing.
not going to be presenting on whether or not it's been used as a residence.
We should coordinate offline to have an efficient meeting.
Okay, do I have to renotice once we amend our documents?
Yes, you will have to renotice.
All right, well, thank you all. Good night.
Thank you, Mr.
Okay.
Atkins.
Right.
Can I just
Uh,
jump in with the next available date? Is
Yeah,
July
well,
10th?
Well, let's address that offline.
I don't think that's possible. It depends on all the documents.
Okay.
Yeah, we'll adjust that separately.
Okay.
Okay. At this time, unless anyone from the board has any further business, I believe we have reached the end of our agenda, and We'll look for a motion to adjourn.
So moved.
Thank you, Mr. Givens. There's a second. I heard Mr. Cray, I think is a second. All in favor?
Aye.
Aye.
Any opposed? Any abstain? All right. We stand and adjourned at 11 minutes past 8 o'clock.
Good night, all.
Thank you,
Right, good
everyone.
night.
Bye.
Bye-bye.